All right. The Honorable Justices of the Montana Supreme Court.
Good morning.
This court is now in session.
Good morning. I want to welcome you to the argument of Stephen Wayne KEEFE versus the State of Montana, cause number DA 190368. My name is Mike McGrath. Before we get started, I want to make a couple of remarks. First of all, I'd like to thank all the technical people that have been involved in this, both at the State Bar and on our staff, for putting this together. As you might guess, you've been, those of you that have been at the convention have been at this for a couple of days. They're interesting times that we're in now, and we have to adapt to what's going on in the world, and this seems to be working pretty well for us. So I want to thank you all for coming today to the argument, particularly the State Bar, as well as the law school for helping us with the introduction. Before we get started, let me introduce the other members of the court in no particular order other than our senior justices, Justice James Rice. Then we have Justice Lori McKinnon, Justice Ingrid Gustafson, Justice Beth Baker, and Justice Dirk Sandifer. Justice Jim Shea is not available today. He will be participating in this case, though, and will pick up the argument at a later time. The counsel ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Mr. Mills.
Good morning, Your Honors. Mr. Mills appearing for Mr. KEEFE. At what I guess is our virtual counsel table with me is Alex Raid of the Montana ACLU. I'm going to attempt to reserve approximately 10 minutes for rebuttal. Your Honors, this case concerns constitutional questions arising from the United States Supreme Court's substantive limitation on sentences of life without the possibility of parole for all but the rarest of juvenile offenders. Today I'll focus on two issues. First, the application of what the parties have denominated the Miller factors, and secondly, the denial of expert assistance. Turning to the Miller factors, Judge Pinsky's principal error was his constitutionally intolerable willingness to consider new evidence only to the extent it was unfavorable to Mr. KEEFE. At the beginning of our 4-hour resentencing proceeding, Judge Pinsky announced that he'd need the last hour of the hearing to announce his order. He also issued two rulings. One, without having heard any sworn testimony, was that Mr. KEEFE's account of the offense was cockamamie and contrived and could not be mentioned by either party. The second one was that any new evidence, any evidence that arose after the time of the original offense, had no legal basis for being considered by the court. At the same time, in the district court's order, it relied extensively on Mr. KEEFE's account of the offense and in terms of holding it against him. Likewise, held against him his tattoos, which again he acquired after the time of the offense. It relied on his reported lack of remorse, again after the time of the offense. This distortion led to a misapplication of each of the Miller factors. The district court misapplied rehabilitation, Mr. KEEFE's rehabilitation, the circumstances of the offense, Mr. KEEFE's ability to protect his own interests as he navigated the criminal justice system, and lastly, the impact of Mr. KEEFE's age on his immaturity, impetuosity, and ability to appreciate risks. Your Honors, we agree with the state's argument in Stallman versus Michael. This is at about minute 53 of the argument, where the state says that even at resentencing proceedings, you take the defendant as he stands. And surely a sentencer, if a defendant, for example, had shanked a guard after the time of the offense, that's something a sentencer would have wanted to hear. And we believe that sauce for the goose is sauce for the gander. That's consistent with Montgomery versus Louisiana in the penultimate paragraph.
Excuse me, Mr. Mills, but you were able to put on that evidence, were you not? It wasn't excluded.
Your Honor, two responses to that. First, we were allowed to proffer our evidence of Warden Mike Mahoney and CO Robert Shaw. However, Judge Pinsky made it crystal clear that he was not considering that evidence on the merits. He did make an alternative statement that he was unmoved by it, but if you look at the court's discussion of each of the Miller factors, there's no discussion of the substance of our presentation. There's only a discussion of new evidence that arose after the time of the offense. And then secondly, Your Honor, we were not allowed to put on any evidence concerning Mr. KEEFE's account of the offense. That was wholly contrary to Mr. KEEFE's interest and entitlement to present evidence concerning the circumstances of the offense. Now, it's worth noting that Mr. KEEFE's account of the offense is not a defense to first-degree murder. He remains liable for first-degree murder under his account, which only highlights its relevance at sentencing and not at guilt. It's an account that, to reference Miller, speaks to the influence of his family and his peers and those older than him in his conduct at the time of the offense. And yet the district court, again, without having heard any sworn statements from either party, decried that account as cockamamie and contrived. And furthermore, Montgomery versus Louisiana, again, in the second to last paragraph of that case, is describing the kind of evidence with regards to rehabilitation that a court would want to consider. And it describes Mr. Montgomery's participation in prison programming. It describes him working in a t-shirt silk screening factory, his coaching in a boxing league. And it describes that as just the kind of evidence that a court would want to consider. Yet Judge Pinsky held that there was no legal basis for considering any evidence that arose after the time of the offense.
Mr. Mills, just a question about the legal basis. This is Beth Baker. If we agree with your position that the district court should have considered post-incarceration evidence, does that mean that a juvenile sentenced today under Miller would be entitled to come back, I mean, assuming a juvenile sentence to life without parole under a Miller hearing would be entitled to come back in 20 or 30 years and challenge the constitutionality of his sentence because the findings of irreparable corruption proved wrong in his view?
No, Your Honor, for two reasons. First, a procedural one. The only reason we're able to obtain a resentencing proceeding in this case was the extraordinary holding of Montgomery versus Louisiana and Steinman versus Michael, right? Holding that the protections of Miller are retroactively applicable. Normally, once a case is final, there's little ability to bring new claims. Secondly, though, perhaps underlying this question is a sense that there may be some windfall that accrues to Mr. Key that might not be available to other juveniles. It's certainly our hope that at a new Miller sentencing, should the state of Montana decide to ever engage in one again, that the decision that was made would be a reliable one that would be the same decision made after 20 years of new evidence. And so to the extent there is a windfall here in this case, it doesn't accrue to Mr. KEEFE, but accrues to the sentencer. The sentencer has 3.5 decades of information upon which to make its decision about whether rehabilitation is impossible, to quote Montgomery. And we think it was error to turn a blind eye to that helpful information. Considering post-offense conduct is, again, consistent with the Montana sentencing statute, which allows broadly consideration of aggravating and mitigating circumstances. It's also consistent with the overwhelming majority of jurisdictions that have considered the question. The Juvenile Law Center's brief at pages 13 to 14 collects those decisions. And finally, it's consistent with sentencing practices broadly. The United States Supreme Court in Pepper versus U.S. has said that sentencers should have the fullest information possible considering the defendant's life and characteristics. And so we just asked that the court adopt the position that the state offered in Stileman, which is that a sentencer take a defendant as he stands. With regards to the third Miller factor, Mr. Keefe's ability to protect his interests in the criminal justice system. The court necessarily was unable to consider that factor because it excluded Mr. Keefe's best evidence on it. So, for example, if Mr. Keefe had been able to offer his new account of the sentencing proceeding, the court could have considered, for example, his ability to share that account with his public defender when he was 17 years old. Had he been able to do so, perhaps he would have been able to negotiate a mitigated sentence in exchange for his testimony against his former family member. But that factor wasn't considered at all by the district court. And as regards to the immaturity at the time of the offense, we provided extensive briefing on the court's failure to meaningfully consider that one. That's at pages 33 to 38 of our brief, in our reply brief at 13 to 16. But we would offer that the court can issue a narrow ruling on this question, which is that at Miller resentencing, a court takes defendants as they stand and must consider evidence aggravating and mitigating when deciding on the appropriate sentence. Turning to the denial of expert assistance, Your Honors, the district court violated Ake versus Oklahoma on both prongs. Ake entitles the defendant to 1, an appropriate examination, and 2, to assistance in the evaluation, preparation, and presentation of the defense. The district court's order is part of the appendix, and the order itself demonstrates that it was not an appropriate examination. Dr. Page was asked only to answer retrospective questions about Mr. Keefe as he existed as a 17-year-old. But even if you disagree with that, it was still an appropriate examination because, 2, Dr. Page forswore any knowledge of what rehabilitation meant as a concept. Maybe that's within his discretion. However, that would have rendered his examination inappropriate to the task of a Miller resentencing.
I don't think he denied it as a concept, did he? He just denied a specific legal definition.
He claimed to have no understanding of what it meant. That's the way I understood his testimony, Your Honor. But
I read it.
Even if you agree that Mr. Keefe received an appropriate examination, there can be no dispute that Mr. Keefe was denied the assistance of an expert in the evaluation, preparation, and presentation of his defense. The court's order does not, as in McWilliams versus Dunn, Dr. Page was, quote, never ordered to provide those functions, and indeed he did not provide them. For example, we asked Dr. Page to talk to Warden Mike Mahoney. Warden Mahoney had powerful evidence about Mr. Keefe. He knew Mr. Keefe for over 3 decades. He had reviewed Mr. Keefe's prison records, and he had worked with him and described, again, Mr. Keefe's evolution from what he described as adolescent immaturity into a mature and empathetic adult. We wanted assistance in evaluating that, yet Dr. Page never spoke with Warden Mahoney. Likewise, Dr. Page never spoke with Mr. Keefe's mother. Dr. Page relied extensively on Mr. Keefe's exposure to trauma, as did the district court. We thought that having the key expert in the case talk to someone who was a first-person witness to that trauma and a first-person witness to Mr. Keefe's development as a juvenile would have been helpful, but Dr. Page did not do that. Now, again, maybe that's fine in terms of an appropriate examination, but clearly we were denied his assistance in evaluating that evidence, in preparing and presenting our defense. Now, Respondent has raised a couple of arguments to the contrary. On the law, it argues that AIC is limited, 1, to capital cases, and 2, to cases where insanity is at issue. First, with regards to capital cases, this court, in its 2015 decision in State versus Beach, at paragraph 10, has recognized that the United States Supreme Court in Miller requires the same exacting scrutiny in juvenile life without parole cases that are required in capital cases. That's because Miller imported the individualized consideration requirement present in capital cases to juvenile life without the possibility of parole cases. For that same reason, Article 2, Section 15 of the Montana Constitution, which provides enhanced protections for juveniles, ought to entitle Mr. KEEFE to appointment of an expert. If he was facing death, he certainly would have gotten the expert assistance required. That's the maximum sentence available to an adult. He was facing a sentence akin to death, to quote Graham, versus Florida, and for that reason should have been entitled to the expert assistance that he would have had had he been an adult facing death. Moreover, we've collected cases in our reply brief at pages 2 to 3 where counsel has been held ineffective in non-capital cases for failing to avail themselves of expert assistance with regards to scientific questions. Here, the scientific questions are inextricably intertwined with the constitutional questions. In each of the court's decisions extending protections to juveniles, it talks about the neurodevelopment of juveniles and our evolved understanding of neurodevelopment. We would have liked some assistance and would frankly be concerned about being held ineffective if we hadn't had at least requested that assistance we never received. Turning to the insanity point, the court need look no further than AIC itself to rebut that position. AIC in Section 3B Sorry, Justice Rice, I can see you're talking, but I can't hear.
I can't hear you either, Jim. Are you muted?
Well, unfortunately, I was unable to read your lips, but I will address AIC for a moment here. AIC talks about future dangerousness and the appointment, need for an appointment of a psychiatrist where future dangerousness is at issue, a construct very similar to irreparable corruption. It's therefore no surprise that in Tuggle versus Netherland, another U.S. Supreme Court case, the court held per curiam that appointment of a psychiatrist was required where future dangerousness was at issue, just as a sentencing factor, not even as a threshold eligibility question like we have here. So insanity is not a requirement. It's not limited to capital cases, and the respondents' legal positions fall in light of those. On the factual argument, again, the court's order appointing Dr. Page, pages 1 to 2 of the appendix makes it clear that Page was never ordered to assist Mr. KEEFE. Again, on this issue, there's a couple of narrow rulings that we would offer to the court that are available. First, where the court itself puts a defendant's mental health at issue, here by Judge Pinsky appointing his own expert, then the defendant is entitled to expert assistance in preparing his defense regarding those issues. Another narrow ruling that we would offer is that in cases where a defendant faces death or a juvenile faces a sentence akin to it, and where their mental health is at issue, appointment of a psychiatrist or a psychologist is required to assist them. Well, left without experts to assist us, we're unable to provide the court with the evidence it would need to carefully consider the full range of relevant evidence to its decision about whether to impose a sentence of life without the possibility of parole. There was quite a lot of evidence available that strongly suggested that Mr. KEEFE had been rehabilitated. Judge Pinsky refused to consider that as a matter of law, and he also prevented us from being able to develop our own psychological and psychiatric evidence in support of a sentence less than life without the possibility of parole.
Mr. Mills, this is Laurie McKinnon. Can you hear me?
Yes, Your Honor. Thank you.
All right. So in Montgomery, and I guess I'm troubled by the post-sentencing evidence and some of the principles underlying that, and the statement made by the Supreme Court in Montgomery that you rely on and which is compelling is the petitioner's submissions are relevant, however, as an example of one kind of evidence that prisoners might use to demonstrate rehabilitation. And again, that's the boxing league and everything post-sentencing. But is the court really saying that you evaluate the defendant at the resentencing as the defendant is there, or that you're reevaluating the decision made by the initial sentencing court and as to the defendant's potential for rehabilitation, and that this other evidence helps support that decision was incorrect?
Well, first of all, either take would require reversal here, right? Because the court refused to consider the post-offense conduct at all. However, it would be an unusual exercise to sentence a defendant by trying to go back in time and reimagine the defendant as he existed, perhaps 3.5 decades ago. As I think it was Justice Baker referred to earlier, it is the unusual case where a defendant can bring 3.5 decades of post-offense information to the court, but we don't think that's necessarily only a defense-friendly outcome. We would want we think the full range of post-offense conduct is fair game in a resentencing proceeding. We think that the statute requires that the sentencer sentence the person before them, not an imagined prior version of themselves. And we think that as a practical matter, that's what a court would want to consider when trying to make a very difficult decision about whether someone is irreparably corrupt. That's what the Ninth Circuit en banc held in Briones versus United States. That's what was underlying the court's decision in United States versus Pete, when it required appointment of an expert to evaluate the 10 years since the original sentencing. Why wouldn't we want a sentencer to consider the broadest range of information when making such a high stakes decision? It reminds me of the Justice Marshall's decision in Ake, where the consequence of error is so great, the relevance of the responsive, the error of psychiatric testimony, but just post-offense evidence so compelling and evident. Why wouldn't we want a sentencer to consider that information? Now, it's going to be in the rare case.
I guess, counsel, I understand what you're saying, and I agree with you to a large extent. However, having looked at the pre-sentence investigation that the initial sentencing court had, and the information that was in front of that judge, and the recommendation for life without parole, and I mean, I would be hard pressed as well to impose a different sentence at that point than what was imposed. Now, obviously that was 30 plus years ago, but there's a certain idea of having finality to judgment. So,
yes, Your Honor, and again, it is the rare case where a final judgment is upended, right? It's the rare case where there's a retroactively applicable rule of constitutional law, but here it's where the stakes couldn't be higher, a sentence akin to death, and we would want a reliable decision in light of the incredible stakes at issue.
Thank you.
Well, seeing no further question, Your Honors, I'll reserve the remainder of my time.
Well, what about the jury trial issue? What about Apprendi?
Yes, Your Honor. Thank you. First of all, if you resolve either of these questions, other questions in our favor, no need to even reach the Apprendi issue. However, Apprendi makes clear that where there is a factual determination, the Sixth Amendment demands both a beyond reasonable doubt finding on that fact and a finding by a jury. Judge Pinsky recognized the question of irreparable corruption as a threshold eligibility question for being able to be sentenced to life without the possibility of parole. He also agreed that beyond a reasonable doubt was the standard to apply, but beyond a reasonable doubt moves together with a jury finding. Now, the respondent has said with regards to Apprendi, that would mean that we're taking a position contrary to judge sentencing. No, we're not. It is just the jury making the eligibility findings. A judge would still be free to choose the appropriate sentence in light of eligibility. It doesn't follow, a finding of irreparable corruption does not demand a sentence of life without parole. Instead, it's just a threshold inquiry for eligibility of life without the possibility of parole.
Go ahead and finish.
No, so just it follows then that it's not that you only get a sentence or beyond a reasonable doubt finding, which Judge Pinsky did provide, but you also get a jury finding.
So in terms of a jury, would you recommend that instructions to the jury would be to give them the Miller factors and have them evaluate that in terms of determining irreparable corruption, or how would that work?
Yes, Your Honor. I mean, the Miller factors provide the kind of information that a fact finder needs to be able to consider in making its determination. So yes, the defense would be able to present evidence on each of the Miller factors and present argument on each of the Miller factors, and a jury would be required to make a finding on irreparable corruption.
So you would, excuse me, so you would put that as a question on a jury verdict form, instruct them on the Miller factors, and then in addition to the question of guilty, not guilty, is there incorrigible or
irreparable corruption?
Irreparable corruption.
Well, there wouldn't be any guilty or not guilty, because that's been determined.
Well, right, but I mean, if you were presenting a new case to a jury, you're advocating that.
Yes, Your Honor.
Mr. Miller, I guess I'm confused about your comment that we would not need to reach this issue if we decide in your favor on your first two arguments. I mean, if we decide that a new sentencing hearing is needed to consider the things that you have brought up, why doesn't that automatically bring into question whether that new hearing must be held in front of a jury?
Sure, it does raise that question. I agree with that, Your Honor. To get to the point of requiring a resentencing hearing, we need only answer one of the other two questions raised here. But certainly, whether or not a jury needs to be impaneled would be at issue on remand for resentencing. One other point with regards to remedy, however, Your Honors, we've not discussed it today, but one of our arguments with regards to the application of Miller is that the state failed to make its case for eligibility. That's reflected in Judge Pinsky's finding that Mr. KEEFE is, quote, now stable, that he's no longer subject to the influences that led him to commit that crime. It's reflected in Dr. Page's conclusion that he no longer presents a risk, that he is not presently, that he presently can be moved safely into the community given the circumstances that Dr. Page outlined in his report, and a finding that the state failed to make its case under Mullington versus Missouri and double jeopardy principles, as well as fundamental fairness, would counsel in favor of a ruling that he's not to be subject to a sentence of life without the possibility of parole upon remand. So the only remedy available is not simply a resentencing, but also a resentencing that excludes life without the possibility of parole as an available sentence.
Mr. Mills, I'm still somewhat perplexed by this discussion of remedy, because there seems to me to be considerable ambiguity between the discussion that we've just been having in response to the other justices' questions about remedy and the pretty straightforward positions that you've taken in your brief about remedy. And at two different places, which are the only discussions of remedy in your brief, it seems to me that you say at one point, quote, all he seeks is an opportunity to make his case before the parole board, end quote. And I guess in my mind, if the substantive essence of your position on appeal is that the state hasn't made a sufficient case, or the judge hasn't found sufficient evidence to justify a life without parole sentence, that we don't need to remand this thing back for a new sentencing if that's the finding that we make in the case. Why wouldn't it be just simple enough to strike the parole eligibility restriction due to lack of evidence and avoid having to send this thing back for a de novo sentencing hearing?
Two responses, Your Honor. First, if you do find that there was an inadequate showing of irreparable corruption, you're right. A holding that forecloses the reimposition of life without the possibility of parole is appropriate. However, the way the sentencing package was done here forecloses a mere striking of the parole ineligibility element of defense as an adequate remedy. In Stalman, the court recognized that, assumed for sake of argument that at least 55 years sentence, right, constituted life without the possibility of parole. And the way the sentences are constructed here more than implicates a life without the possibility of parole sentence, even if the court strikes the no parole condition.
See, that's where I find the patent ambiguity here, because that, number one, as a threshold matter, seems to be a broader position that you're taking here at oral argument than in your briefs. But secondly, be that as it may, then you're not just challenging the parole restriction here, the life without parole restriction here. You in essence, are further challenging the length of the sentence. Isn't that true? Or isn't that the upshot of what the position that you're taking at this oral argument?
It's true only insofar as that we want the opportunity to obtain parole to be a meaningful one. We don't want an empty hearing in which he just moves from one life sentence to the next with no opportunity for release within his lifetime. That was the essence of that comment. If he had been given a meaningful opportunity to obtain release by Judge Pinsky, including appearing before a parole board, as Montgomery makes clear, then our Miller issues would have been mooted. However, because he was not provided a meaningful opportunity to obtain release, the sentences as imposed are unconstitutional.
I'm going to leave you alone I want to give you one more question, and I'll quit badgering you about this. I can't get my mind around the distinctions you're trying to make here, because it seems to me that if we strike the parole restriction, if we found merit in the rest of your argument in substance, I don't understand what the remaining constitutional defect would be in this process. And could you explain that to me, please?
The court would need to look at the practical effect of striking that. And if Mr. Keefe is not giving a meaningful opportunity to obtain release, to be paroled, then there's no difference. And again, given all of the consecutive sentences, that's what gives rise to the problem we're highlighting here.
But didn't, oh, sorry, Beth.
No, it's me, Ingrid. You go ahead.
Oh.
And I have Jim Rice's question as well. He got it to me another way, so.
Go ahead, Justice Gustafson.
Well, I was just to say, but in your briefs, you argue he is, but for the life without parole, he's eligible to go for the parole board. So are you saying that even though he would be eligible to do that, he can't meaningfully get any kind of good hearing there?
It's not the content of the hearing, Your Honor. It's the prospect for release. Meaningful opportunity to obtain release is what the Constitution requires. And so he needs a sentence that, and including a parole eligible sentence. That's one way to get there, right? Another one would be a term of years that ends within, at least 55 years, according to Stileman, right? And the sentence as imposed well exceeds that. And so that's the problem that has come up to date in oral argument. And the comment about a opportunity at a parole hearing is, again, just reference to parole as a potential remedy for a life sentence. But it does have to be a meaningful opportunity and it's not the content of the parole hearing, it's just the upshot of having a parole hearing. If at the end of the parole hearing, no matter what the parole board says, he has to go back to the cell, that's not a meaningful opportunity to obtain release.
So you've got 6.5 minutes roughly left for rebuttal. Perhaps we should move to Mr. Brown and allow Mr. Mills some time for rebuttal.
Thank you, Your Honor.
Thank you, Your Honor. And may it please the court. My name is Roy Brown. I'm an assistant attorney general and I'm representing the state. The state will limit the issues to the issues raised by opposing counsel in argument. First, this court should affirm because KEEFE's due process rights were effectuated when the district court provided a psychological expert to explore the mitigating circumstances of his youth. And this resentencing hearing was a fundamentally fair hearing, and KEEFE received the basic tools to support a viable defense. And second, the district court properly examined the Miller factors and the mitigating circumstances of youth, and its findings were supported by substantial evidence. And now I would like to turn to opposing counsel's argument that a defense team expert is required by the Constitution and explain why that is incorrect. But it's important to provide some context here. In 1985, the Supreme Court decided Ake versus Oklahoma, where it said, when the defendant places his sanity at the time of events at issue, the defendant is entitled to one competent psychologist sufficiently available to the defense, but independent from the prosecution. But the defendant also is not entitled to a competent psychologist of his own choosing. So this created some ambiguity over the next 30 some years, and courts came to different conclusions on this issue, whether a neutral expert could satisfy Ake or a defense team expert could satisfy Ake. But ultimately, a couple of years ago in McWilliams versus Dunn, the Supreme Court answered this question and said, you're focusing on the wrong inquiry, lower courts. The question is not whether a neutral expert or a defense team expert can satisfy due process, but the question is whether the defendant received the basic tools to mount a viable defense. And so now I would like to explain why KEEFE received those basic tools to mount his defense, and just taking you through exactly what the district court did in this case.
Mr. Brown, excuse me, before we get to that, following up on the end of Mr. Mills's argument, who has the burden in this case?
Well, Montgomery answers that question, Your Honor, and it says that prisoners must be given the opportunity to show that their crime did not reflect an irreparable corruption. And this court repeated that in Steelman. And Your Honor, if we look at even death penalty cases, the burden to prove mitigating circumstances is on the defendant. So yeah, now I would like to turn to how the district court effectuated this due process. And so what the district court did exactly was he appointed Dr. Page to evaluate KEEFE and explore the mitigating circumstances of youth, and not only how children are psychologically different, but explore all 5 factors with KEEFE. And the district court did not say, this is all you can find. The district court said, quote, at a minimum, you must find these factors. So it did not limit the scope of what Dr. Page could find. Dr. Page performed this evaluation and consulted with KEEFE multiple times. The record shows at page 2 of the mental health evaluation, consulted with KEEFE and his attorneys multiple times, thereby allowing KEEFE to develop mitigating circumstances and to prepare an adequate defense. And finally, Dr. Page gave this evaluation to both parties prior to the resentencing hearing, again allowing KEEFE to develop mitigating circumstances. But Dr. Page testified at the resentencing hearing as well. And so both parties were able to test his findings and conclusions during this hearing. So KEEFE received the basic tools that AIC requires to mount a viable defense. And so now I would like to turn to the application of the Miller factors, and specifically to discuss this issue of rehabilitative evidence. And I want to start by explaining exactly what the district court did here. Opposing counsel argues that the district court refused as a matter of law to consider this rehabilitative evidence, but that's not what happened. The district court did not refuse to allow the evidence to come in and gave it zero weight. Rather, the district court allowed all this evidence in, weighed and considered it, and decided it was not mitigating. So the district court considered the totality of the rehabilitative evidence in this case, and there can be no argument that it refused as a matter of law to consider it. But even if we look into...
But didn't you, they weren't allowed to present the testimony of the warden and that type of evidence. So, I mean, were they really allowed a full evidentiary presentation for the district court to consider and then deny?
Your Honor, the warden testified at the resentencing hearing.
All right. So I guess I was just following up on a comment earlier, I guess, from Mr. Mills, that they weren't able to present
Your
all
Honor,
of that.
Yeah, the entirety of KEEFE case at resentencing was this sort of post-incarceration rehabilitative evidence. I mean, KEEFE had the warden testify as well as a prison official testify, and they attempted to show mitigation through this post-incarceration rehabilitative evidence. The district court ultimately just gave it little weight. But I can discuss sort of the content of this evidence and why it is not mitigating. And we can look towards Brian's, Your Honor, the Ninth Circuit case, where the prisoner in that case spent the entirety, well, he was the getaway driver from a felony murder, and he was convicted to life without parole. But he spent the entirety of his prison sentence so far, 18 years, without a single infraction of the prison's rules. But that's not the situation we have here, Your Honor. We have 15 prison violations going from 1987 to 2007. And these violations are significant, including attempting to escape prison, having a shank in his possession, stealing, drinking, making alcohol. And so for up until the time KEEFE was 40 years old, there's conduct that suggests that he was not attempting to mature and not attempting to rehabilitate himself. But so when KEEFE turns 40 years old, did he suddenly decide to mature? No, Your Honor. I think the question, I mean, the most logical answer is the one that KEEFE gave himself to the PSI investigator, that his recent conduct was motivated by advice from his attorneys, not from a need for personal improvement. But even if we look at the content of this rehabilitative evidence itself, it still does not show mitigation. KEEFE argued that, he was rehabilitated because he was good at accomplishing tasks and got along with prison staff, but that's entirely consistent with his character profile as a youth. He was good. He was a good worker. He was charismatic. He got along with people, and then he committed a triple homicide. So I don't think any of that evidence is mitigating. But finally, Your Honor, we can't just look at
Mr. Brown, I got to challenge you on that. The standard isn't whether he's rehabilitated today, or the standard was or is whether he can be rehabilitated or is subject to change as he has matured over the years, as it relates to a justification for a life sentence without parole. So I don't understand either how the particular facts of the case, as heinous as they were, are probative of his ability to be rehabilitated or rehabilitative at a later stage of the development in life, or how the fact that he may not have initially conducted himself appropriately in prison necessarily forecloses a finding of fact that he can be rehabilitated, or he's subject to being rehabilitated.
Yeah, Your Honor, and I think that, you know, what we're looking at here, and it's a very difficult inquiry because we're looking at his, you know, his behavior in a very controlled environment where, you know, good conduct is encouraged and compliance is encouraged and bad conduct is punished. So I think that goes to the weight where the district court ultimately gave this evidence, Your Honor. But we can't look at the last 11 years in a vacuum, Your Honor. What we need to look at is the totality of his behavior, not only in prison, but prior to prison, because the most predictive evidence of how KEEFE will behave outside of a prison environment is how he has already behaved outside that environment. And Your Honor, what we have is 50 crimes of escalating severity and then resulting in a triple homicide, but also KEEFE failed at every youth rehabilitative facility in Montana.
But let's talk about that for a second. Fair enough, and that's an undisputable fact in the record, but where in this record is there any consideration of the modern brain development science or behavioral science that was the whole predicate for Miller and Montgomery in the first instance?
Well, Your Honor, I would refer you to the mental health evaluation done by Dr. Page, where he explained the general differences between children and adults from a psychological perspective. And not only that, he applied them to KEEFE. But I would also refer you to the opinions of Montgomery and Mills itself, which the district court said that he read and he understood. And in its recitation of the judgment, the district court said how children are different from constitutionally different. So I believe there is evidence in the record to support that.
But didn't Dr. Page also conclude now that there has been some rehabilitation and that he, under right circumstances, he could be released into the community, which would tend to indicate, you know, against irreparable corruption or permanent incorrigibility?
Yeah, and Your Honor, I mean, Dr. Page said that there was evidence of growth and maturity, but the extent to which that could be determined was very difficult because you're in a controlled prison environment where KEEFE has been subject to 30 years of consistent programming and controlling to ensure its conformity in prison. So, you know, I think that I think that's a fair point, but also that the district court properly gave this little weight.
Well, in your estimation, Mr. Brown, what evidence could have been brought into court in this case or in any similar type of a case that would be adequate from the state's perspective to show that a young defendant who's been sentenced to life without parole can be rehabilitated?
Again, Your Honor, I would point you to Brian's, where the defendant spent the entirety of his prison sentence without a single infraction of the prison's rules. We have 20 out of 30 years that he's been in prison where he has been non-compliant. So, I mean, I'm not saying that there isn't some recent clear conduct, but we need to look at the totality of this rehabilitative evidence to make that determination. And the district court properly gave it little weight. And I want to remind you, Your Honor, that this court is not reweighing the evidence or the credibility of the witnesses on appeal. It is only looking at whether substantial facts support the district court's findings.
So perhaps you could address the Apprendi issues at this point.
Sure, Your Honor. And, you know, Apprendi, excuse me, Your Honor, in Oregon versus ICE, an Apprendi case, it really summarized what Apprendi is trying to get at here. And it said Apprendi's core concern is a legislative attempt to remove from the province of the jury the determination of facts that warrant punishment for a specific statutory offense. And now, Your Honor, KEEFE was eligible for the sentence of life without parole at the time of his original sentencing. And actually, he was eligible for the death penalty, but was able to mitigate against that based on his age. But KEEFE is similarly eligible for the sentence of life without parole today. There are no facts from the jury's verdict that would take him outside of the statutory range for Apprendi to be applicable. I mean, ultimately, what we're talking about here, Your Honor, is Eighth Amendment facts, not Sixth Amendment facts. nothing prevents a district court from considering the offense and the offender and making a proportionality determination under the 8th Amendment within the statutory range. And even in the Apprendi cases, Your Honor, the court consistently recognizes that fact. We're not talking about 6th Amendment facts here.
Mr. Brown, before you get to your next issue, do you dispute Mr. Mills's contention that we should take the KEEFE at the time of the resentencing as he is? In other words, all of the evidence, or are we looking backwards to the first sentencing and trying to determine whether that still remains the case in terms of the incorrigibility?
Well, yeah, and that's a really good question, Your Honor. And I want to start with, as I explained earlier, the district court didn't refuse as a matter of law to consider all this evidence. So he allowed all of it in. So, I mean, the question is not necessarily what rehabilitation evidence is relevant because, that could be answered based on the facts of this case. But, the state's not going to offer a specific position on what type of rehabilitative evidence is relevant. And, recognizing, Your Honor, that we're in new territory here, and also recognizing that KEEFE is the only juvenile homicide offender that is serving a life without parole sentence in Montana. So the state is asking for a more narrow holding as applied to the facts of the case when that will do, when a broader holding is not needed. But also recognizing that we're going to get additional Supreme Court guidance in the upcoming years. I believe I've addressed all the salient
Mr. Brown, let me ask you one question here. We're having this discussion about remedy here, the appropriate remedy. I know the state doesn't agree that it takes the position that there's no basis for us to impose a remedy, but in the event that we were to find some substantive merit in the defense position on this, what is the state's position as to what an appropriate remedy would be?
Well, I mean, normally, Your Honor, with the resentencing, if it can't be corrected, then it needs to go back to the district court for a resentencing. But I mean, I guess I would, Montgomery talks about, considering an offender for parole rather than resentencing him. But I think the scope of what the court was talking about was a legislative fix, not necessarily a judicial fix in this manner, Your Honor, because the court cites a Wyoming statute and says, look, this state has allowed someone to be considered for parole instead of resentencing them. And so that's how the dissent characterizes it in Montgomery as well, Your Honor. And so I'm not sure that there's an easy answer to your question. This court, of course, has the authority to strike a parole restriction if it finds insufficient facts for irreparable corruption. But yeah, so I'm not sure, Your Honor, to be honest.
Well, let me ask you this question, which is admittedly a leading question, but wouldn't that fit the bill for what you're talking about here as far as having a narrow and limited holding, particular to the facts of this case?
Well, Your Honor, the state doesn't, we believe that the finding of irreparable corruption was found beyond a reasonable doubt, and the district court supported its Miller factors with substantial facts. But that sort of a narrow holding principle wouldn't necessarily be a remedy in this circumstance that could be, applicable. But I understand that's not a great answer to your question, but.
You're the wrong guy to ask. I just want to see what you thought.
Let me follow up. This might be an opportune time for me to give you Justice Rice's question, because it's not too dissimilar from that. And just a second, I'm trying to pull it back up. He asked about the array of issues that Mr. KEEFE has presented and the different factors. Where are we left if we agree with some of the defendant's arguments, but not all? Do we assess harmless error? Must any remand be for a complete resentencing, or could it be limited to certain issues?
Well, Your Honor, and that's a really good question, but I think, you know, if there's insufficient evidence to show irreparable corruption in this case, it should be probably a remand for resentencing. But, you know, and I missed all the parts of that question, and I'm sorry.
Well, I think the question
Justice
is,
Rice is muted. So.
Yeah, and I guess could the resentencing be limited to certain issues? So, such as, one piece of evidence that KEEFE argues he wasn't allowed to put in was the evidence of his version of the offense, or, you know, expert testimony from his own expert. If we agree with part of that argument and not the other part, could we remand for consideration of certain issues at a resentencing, or just throw the door open for the district court? I hope I'm asking your question correctly, Justice Rice.
Good. And I mean, you know, the state would dispute that, you know, that that the part, you know, like about the expert, that he wasn't given an expert to his defense because, you know, due process was effectuated this way. But I mean, it depends on the issue, definitely, what the remand would be. But ultimately, what a district court needs to do here is adequately examine the Miller factors and come to a conclusion. And if there was insufficient facts for that, it would probably be a remand for resentencing.
Thank you.
Was the defense prohibited from putting on evidence from Mr. Keefe's family members or people like that could have given testimony about his personal situation at the time of the offense?
Not that I know of, Your Honor, and maybe that's a better question for opposing counsel, but I believe that
he said that they were prohibited, or at least having an expert examine that.
Oh, okay. So he was saying that an expert did not. Okay, so Dr. Page did not consult with Keefe's mother, and Your Honor, Dr. Page consulted with a lot of stakeholders, including you know, lots of people at the prison as well. And I believe Dr. Page said he attempted to get in contact with Warden Mahoney, but they never connected. But ultimately, Dr. Page did a thorough evaluation here, and I think, you know, his findings speak for himself.
So, counsel, I'm having trouble tracking in terms of the burden. Again, I'm stuck on that, but I agree. Montgomery says an opportunity to present that he was not irreparably corrupt. So we've got this hearing, and he's allowed to present evidence, but then we shift, and we're now talking about whether the state has presented sufficient evidence to demonstrate that. And I guess I want to be clear going forward how we're supposed to navigate this in terms of the burden, who's met it, and also in the context of what the district court's findings and decisions ultimately were. Right.
And I mean, the state's position that it is the defendant's burden to show these mitigating circumstances. And I think, you know, your question kind of turns on what is irreparable corruption and how does that play into a district court's findings and conclusions? Would that be an accurate? And Your Honor, irreparable corruption it simply encapsulates the absence of youth-based mitigation. In other words, if the defendant has not shown mitigating factors, then that youth is irreparably corrupt. But another way of looking at it is it's the characteristics of the defendant. You know, the Eighth Amendment only prohibits the sentence of life without parole for a juvenile whose crime reflects merely a transient immaturity. So we're looking at both the offense and the offender, the district court is, and making this ultimate sort of judgment in what is an appropriate sentence. So it is the burden for the defendant to show mitigating factors, and it's the state's burden to rebut those mitigating factors. But irreparable corruption is something that's within the sphere of the sentencing court. If there are no other questions, I would close. KEEFE received a fundamentally fair hearing where the district court adequately considered the Miller factors and found that KEEFE is irreparably corrupt beyond a reasonable doubt. This court should affirm KEEFE's sentence and conviction.
Thank you, Mr. Brown. Mr. Mills.
Thank you, Your Honors. If I could start with clarifying a factual point raised by Justice Gustafson. If we look at the appendix at page 16, that's page 2 of Judge Pinsky's order, he says, regarding Mr. Keefe's alleged rehabilitation, the court allows some leeway for Petitioner's counsel to make a record that he has been rehabilitated in prison. Although the court will allow that leeway to make a record, there is no law presented to the court in the sentencing memorandum that it is proper for the court to consider those issues. Okay, so we were allowed to proffer Warden Mahoney and proffer C.O. Shaw, both of whom had powerful evidence with regards to Mr. Keefe's rehabilitation, but the court considered it legal error to consider that. Now, did the court consider it in the alternative and give it a little weight? It's difficult to say how much consideration the court gave it, because if you look at the court's analysis of rehabilitation, it only discusses the state's new evidence. And in discussing the state's new evidence, dismissed evidence of rehabilitation. Furthermore, we were handicapped from being able to develop our case in rehabilitation by the denial of expert services. On the question of expert services, Your Honors, I would encourage the court to look at McWilliams versus Dunn. I believe it's at page 1799 of the court's decision. It's discussing whether a partisan expert is required under AIC, and essentially they decline to answer that question in McWilliams. They don't say one way or the other. The Ninth Circuit has answered that question in the affirmative. McWilliams versus Dunn just doesn't address it one way or the other because they reversed on different grounds. In terms of whether death penalty cases provide an analog, we would submit that they do, and that irreparable corruption is analogous to an eligibility factor, which under Ring versus Arizona is required to be found by a jury beyond a reasonable doubt. Cunningham versus California is a case in which the United States Supreme Court held that a jury must make a finding on an eligibility factor developed out of whole cloth by a judge before raising a sentence eligibility. Ring versus Arizona, again, is an application of the United States Supreme Court's eligibility factor structure that required a jury finding beyond a reasonable doubt. With regards to Briones, the facts will speak for themselves. I encourage the court to look at them. Mr. Briones was a getaway driver, but he was also the organizer of a number of fire bombings. That's what he was driving away from. Bombings that continued well into his adulthood. The facts on Briones will speak for themselves, but there is a bit of distance between the way they're described here. Your Honors, the question is whether or not rehabilitation is impossible, right? That's what Montgomery says. That was the ultimate question for the district court. The testimony of Warden Mike Mahoney, the testimony of the CO who supervised Mr. Keefe for many years, and 3 decades of behavior demonstrate that Mr. Keefe is not the same impetuous person he was at the age of 17. Thank you, Your Honors.
Every defendant can make that argument.
Your Honor, Montgomery makes it clear that it will be the very rare juvenile who's eligible for a sentence of life without the possibility of parole. Where that argument is successfully made, and fairly made in a hearing in which a juvenile is able to develop, evaluate, and present his defense, it's potentially the case that a judge could impose such a sentence, but it will be very rare, and it is a very difficult inquiry to make. And unfortunately, Judge Pinsky turned a blind eye to decades of information. He kept us from being able to evaluate our own case and prepare our own case by denial of any expert services, services that an adult facing the death penalty surely would have gotten. And so as a juvenile facing a sentence akin to death, we wanted to have those as well.
One more quick point on clarification. Was the defendant precluded from presenting family member witnesses to talk about his history at the time the crime was committed?
Your Honor, we, as a point of clarification, we asked for jury trial, and we were given 4 hours. We thought we were going to have 4 hours to present our case, but learned at the beginning of the hearing that we would have, in fact, 3 hours to present the case. So we did have to make some difficult decisions that day. We did offer a letter from Mr. Keefe's mother that's attached to our sentencing memorandum. And it's part of the record before the court. But again, I'd point the court to Judge Pinsky's order on the relevance and admissibility of any evidence that arose after the time of defense. Now, as with regards to whether or not Dr. Page spoke with Mr. Keefe's mother, the record's clear that he did not. And yes, they did have some missed phone calls. I don't know how many, maybe it was one, missed phone calls with the warden, not with Mr. Keefe's mother, but just with the warden. It's not clear how many, and that really speaks to our lack of involvement in the evaluation and preparation of our case with regards to, Dr. Page. It was Dr. Page who said, hey, give me whatever you'd like. I'll consider whatever I think is important. It's not that he was here to help us evaluate and prepare. He was conducting an examination as he saw fit. Query whether his examination was ultimately appropriate or not, but it is clear that we were not given assistance from him. He was not there to help us evaluate our case. Thank you, Your Honors.
Well, this concludes the argument in this case. Thank you to both counsel. We appreciate your arguments. The court will now take this matter under advisement, and we will issue an opinion in due course. Thanks again for the participation from the State Bar and the law school, as well as all the bar members that have attended. We appreciate your attendance. Thank you very much.